Hunter Shkolnik into this conversation. He's a trial attorney and a partner at NSPR Law. Hunter, this case looks at the liability shield. Should the Sacklers be shielded from the lawsuits even though they haven't filed for bankruptcy as their company has? And what could the outcome in this case mean for future businesses?
Well, first and foremost, this is a very technical issue right here. The bankruptcy code does not provide, through its terms, for release of third parties like the Sacklers, parties that have committed crimes, parties that have committed fraud. So this is a unique and an unusual situation that is being used more and more by big corporations to walk away scot-free from liability. Supreme Court took this case up, and remember, 89% of the time when they go up on appeal like this, they usually reverse, meaning I think the odds are that the Supreme Court will say the third-party release of the Sacklers fails. That said, they made some very good arguments today that individuals, by and large, supported this. But what is very important is 3,000 individual claimants, family members of overdose victims, said no, they don't agree with it. They'd rather see the Sacklers in court, subjected to criminal penalties and more.
Hunter, the bankruptcy settlement had mixed reactions from victims' families on whether the Sacklers should be shielded from liability. One reason they don't want any delays to getting paid. How else is this case impacting those families?
Well, you have to understand the individuals who were subjected, or the families who suffered the loss of family members from overdoses, they had very little recourse in the courts. I was one of the lawyers that led this litigation nationally, the opioid litigation, and I participated in the first opioid settlement with Purdue that got unwound when they filed for bankruptcy. There wasn't a lot for the individuals there. But if you look at this settlement plan, contrary to what my friend said a little while ago, these families are not going to see $3,000 to $40,000. There is going to be a lot of claimants that are going to see pennies. I think many of these families, when they see how little they get, they're going to say, why did we let the Sacklers walk away scot-free? This $6 billion, or whatever their personal contribution is pennies on what they took from this company. $35–40 billion is hidden around the world from this, from these claimants, from everyone who's suffering under the opioid epidemic. And these family members, when they see these checks, are going to say, why? Why didn't we put them in jail? Why didn't they answer for their frauds? Why did they get out of jail free card, like many corporations are doing, even though the code does not provide for it?
Hunter, is it possible we'll see the opioid epidemic addressed in the court's opinion?
Well, there's no doubt about it. I mean, they have to deal with it. But what's unusual about the argument today, and in particular what Justice Kagan was talking about, we very rarely don't hear the court talk about the facts of the individual case. You may not realize that when you get to the Supreme Court, it's not the facts of that plaintiff and that defendant or that person. They're usually looking at the law issue. What does the law say? And here the code does not provide for the protection that they're being given, that Sacklers are being given. And once you give the rubber stamp to this one at the Supreme Court level, you're going to see all the companies running to court and doing the same thing. The parent companies are going to say, bankrupt the subsidiary, give us a get-out-of-jail-free card no matter how many people are hurt, even though they have plenty of money to compensate people. The court should do the right thing and not support third-party releases since it's not provided for under the code.
All right, Attorney Hunter Shkolnik, thank you for your insight and time today. We appreciate it.